Hey out there, legal warriors. Have you ever wondered if you can keep driving if you're charged with a DUI? How does that work? What are the pitfalls? What do you need to know? Well, if you're interested in that area of the law, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I've been defending people charged with crimes all throughout Washington State for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. And as usual, I'm just going to jump right into it. We get calls all the time with, unfortunately, somebody who got pulled over for a DUI last night or last week, or maybe it's a spouse calling because their loved one is in jail. And while we have very broad videos in DUI, this is going to be a narrow video. This is about whether or not you can still drive if you're charged with a DUI. So here's the answer. When you get stopped for a DUI, if you blow 0.08 or higher, if you're an adult, 0.02 if you're a minor, or if you refuse a lawful or requested breath or blood test, the police officer is going to send in a jurisdictional document to the Department of Licensing telling them, hey, this driver did one of those no-nos. Blew an 08 for an adult, blew an 02 for a juvenile, or refused a breath or blood test. And when Department of Licensing gets that information from the police officer, they're going to transmit it to Department of Licensing. Someone at Department of Licensing is going to type it into the computer, and they're going to generate a suspension notice. Because the law in Washington State says that we're supposed to lose our license, according to the legislature, for a period of time if we violate those rules. And then the defendant, the suspect, is going to be sent that suspension notice, and here's what it's going to say. Now, you're not going to get it for a week, so that's why you need to know this now. It's going to say, we're going to suspend your license for a period of time starting 30 days after the event. So cutting to the chase, can you keep driving after your DUI arrest? If you're already valid to drive and you're not otherwise ordered not to drive by a court, the answer is yes, you're still good to drive for 30 days after the event. Now, if you want to make sure, you can get on www.dol.wa.gov and check the status of your license. But the rules say that you have 30 days leeway before a suspension starts. And how do you fight about that suspension? We've got all types of videos on it. You're going to send in a driver's hearing request form with a $375 fee unless you can get it waived for being indigent, not being able to pay. And then that's going to typically put the suspension on hold if you follow the rules. So yes, you are still good to drive if you otherwise were valid to begin with for 30 days after the event. If you request a licensing hearing properly, you're going to be good to drive for even longer, more than 30 days after the event, because your suspension will be put on hold until a licensing hearing happens. And that might be a month or two down the line. So how else do we want to think about whether or not we're good to drive? Lance, what if I get convicted of DUI and I suffer a license suspension? Or Lance, I didn't request a licensing hearing within 7 days after I got arrested, so my suspension is going to start or has started 30 days after the event. Can I still drive? Well, the answer is no, unless. No, unless you apply for and are granted a restricted license. That's what Department of Licensing calls it. However, us in society, we typically call it an ignition interlock license. So if you suffer a DUI suspension, most people are eligible to get an ignition interlock license to be able to drive during a period of suspension. How does that work? Well, you have to get a form, or you have to go on your driver's licensing express account on dol.wa.gov and apply for that interlock license, the restricted license. What does that mean? Well, you got to pay $100. You have to fill out the information you're supposed to. You have to put an interlock in whatever vehicle you intend to drive, and you have to get your insurance company to issue an SR22 insurance policy for you, which is basically proof of financial responsibility. And that basically commits the insurance company to tell Department of Licensing if you drop your insurance. So once Department of Licensing has the application with their $100, the SR22 insurance from your insurance company, and the interlock proof from an interlock company, then you'll go in a pile, electronic or otherwise, and eventually Department of Licensing will issue you an ignition interlock license. You are not good to drive unless you have that ignition interlock license in your hand. So if they email it to you, print it, right? If they cash your check for $100 or take your credit card payment, that does not mean you're good to drive. But yes, you can drive during the period of suspension if you're issued an interlock license. So what if you have a blood draw, right? You get pulled over by the police officer, they arrest you for DUI, they don't suspect alcohol, and they never offer you a breath test, and you agree to a blood draw. You don't refuse anything, you do what they say. Can you keep driving then? Well, in that case, again, the fact pattern is there's no breath test more than a .08. You did not refuse any tests, and they did a blood draw to see if you got marijuana or whatnot in you. Are you still good to drive? Well, the answer most likely is yes, because there's no triggering event of a suspension. Department of Licensing doesn't even know about it. Remember, the police officer only sends a notice to Department of Licensing if you refuse something. In this example, you didn't. You blow .08 or higher, or .02 or higher for a minor. In this example, that didn't happen. So they took the blood draw, but Department of Licensing has no authority to act against you because there's no notice from a police officer saying you did those no-nos. So you're still good to drive even if you got pulled over for the DUI because there's nothing that triggered a suspension. Eventually, that blood draw will be analyzed by the state toxicologist, and they'll send that result back to the police officer. If the result is an illegal number, right, it's got more than 5 nanograms of marijuana, if you're an adult, any nanograms if you're a minor, or if it happens to be .08 or higher in alcohol, well then you're not automatically suspended. The officer still has to take an action, and sometimes they forget, sometimes they don't see the blood draw. They've got to send in that jurisdictional document to Department of Licensing that will trigger the clerk to enter something in the computer to send you a notice saying that you're going to be suspended. And in that case, you have 7 days from the date of the notice, not the date you get it, but the date of the notice, to request that licensing hearing to fight the suspension. So the rule of thumb is, are you still good to drive after a DUI arrest? Probably, because there's a delay in things. Probably good. In most cases you will be if you were before. Now the court might order you not to drive if you saw a court. Certain courts do that. The court might order you to put an interlock in. So you got to be careful. You need to contact an attorney. But if you've got questions, check your driver's license status online. It's easy to do. And if you have bigger questions, definitely contact an attorney because we'll probably know what the answers are. So I hope you found this helpful. If so, please like and please subscribe. More people will get to see it. And more importantly, if you need some help, feel free to reach out to my firm. We'll identify a way forward. We will be there for you, and hopefully we can get a great result. See you later.